Hello and good afternoon, everyone. Thank you for joining me on what here is a very rainy lunchtime. Hopefully it's given you something interesting to do while the rain's pouring down. Looking at the list of attendees, I'm delighted to say hello to new and old contacts. For those of you who don't know me, I joined Gunnercooke in January this year. I specialise in real estate recovery and have done for my entire career. Very much enjoying my new role, and for those who do know me, hello once again. It's good to be back. Today is National Love a Tree Day, 16th of May. You may wonder what on earth this has got to do with anything. Just to make it a little more light-hearted, all being well, you will see this image of a tree again throughout the presentation. I won't tell you where if you spot it, and would like to do so, send me an email, let me know where you see it, and next time you're in Leeds I will buy you a coffee. If for almost added bonus you can tell me where in the UK this tree is, then we'll add a cake to that coffee. Before we get started, just to let you know, you may be aware there's a function on the webinars for you to ask questions of me during the presentation via a messenger system. Can I ask that in order to keep continuity of the talk going, and also for me to keep to the 45-minute time limit I've promised, if you do have any questions, drop me an email afterwards and I can give you a call and we can have a chat through the queries you've got. So, without further ado, let's crack on. Lease or license? Now, there are two reasons why this topic has hit the top of my list. Firstly, it's an unreported case and therefore it may not have hit everyone's radar. Secondly, it's just the sort of thing when we're dealing with recovering real estate assets that you might in current times come across. Now, the vast majority of people who have signed up to the webinar today know a thing or two about this, and the last thing I want to do is teach your grandmother how to suck eggs. But what I do want to do is highlight a few points for those who are on the webinar who are less experienced in dealing with this question as to whether a document is a lease or a license in practice. The first thing to note is that irrespective of what a document is called by parties entering into it, it's actually the substance of the document that is important. Now, the leading case on whether a document is a lease or a license is Street versus Mountford. That's from 1985. And it was there that it held that the substance of agreement as well as its form is what needs to be looked at when deciding whether an agreement is a license or in fact a lease. So what's the difference between the two? Very briefly, a license is a personal right. It gives permission for a licensee to do something on a licensor's property. A lease is an estate in land where the tenant is granted the right to exclusive possession of the land for a determinable period of time. A licensee's occupation is precarious, particularly if a landowner sells its interest in the land or the property. In contrast, a tenant's position is much more secure, and an inadvertent grant of a lease may actually mean that the landlord can't obtain possession of the property when he or she might expect. If the property is commercial, the tenant may acquire security of tenure under the Landlord and Tenant Act 1954, or if it's residential, the landlord might obviously need to satisfy certain statutory criteria and procedures before it can get occupation. So we're thinking Section 8, Section 21 notices and things like that. So what stops a purported licence actually being one? Well, where an arrangement has any of the following three characteristics, it might indicate the existence of a lease rather than a licence. The occupier has exclusive possession, if the arrangement is for a fixed term, and if a rent is reserved. Often when it comes to recovering an asset, it's beneficial to have someone occupying a property rather than leaving it empty, but at the same time, you're likely to want to keep your marketing and disposal options flexible, and therefore you might want to offer vacant possession of a property if that's what the market so desires, obviously to obtain maximum value. you can see that most arrangements that receivers or administrators or all those recovering real estate assets are likely to want to put in place of that temporary nature do run the risk of being deemed a lease. And lots of clients over the years have asked me and my real estate team to draw up a licence to provide them with the flexibility. Sadly, in reality, it's actually very difficult to do that, and you often run the risk of creating a lease. We have in practice had individual practitioners who do want documents, and they do run the risk of it being a lease, but sometimes occupiers don't actually appreciate that what they've signed is a lease, or could run the risk of being so, and they vacate on the basis they think they have a license. Not something I would recommend relying on. So let's move on. So turning to the recent case now, interestingly, unfortunately, I found out at the weekend that this is a case where gunnercooke were actually advising one of the parties, and as the case is unreported, we don't think it's appropriate to disclose the parties' names or to discuss all of the facts. However, what we are going to do is highlight the points made by the court, and that's in essence what's going to be of interest in any event. So very briefly, the owners of an empty property were concerned for the security of the building, and they employed a company to find guardians for the property and put in place a guardianship agreement. Now, before we go any further, just a quick word about guardianship schemes in case anyone is wondering what they are all about. They are schemes whereby an owner will arrange for a commercial property to be used typically for residential purposes, placing occupiers, the guardians, into the property. Properties they're typically offered below market rent, which makes the arrangement more financially viable than a traditional residence. Occupiers are then usually given a license to sign detailing the terms of their occupation and the period of notice they will be given if they're required to leave. The property in question had a number of rooms available to rent, together with communal living areas. And the points worthy of note are that the occupiers determined where they slept at this property. The document was called a license. There were various restrictions on use, including not permitting guests to be left unsupervised at the property. There was no express reservations in favour of the landlord. The landlord retained keys to the property and the individual rooms within it, and it carried out regular inspections. The doors on allocated rooms which were rented out could be locked by the occupiers. Notice to quit was served on the occupiers, but they didn't vacate. Possession proceedings were commenced, and they were stayed pending a decision on preliminary issues as to whether the occupiers were occupying as a licensee or under an ASD. Now, County Court held that the agreement didn't reflect the reality of the situation. The occupiers had exclusive possession of the rooms, and therefore the agreement was an AST. Now, the point of interest really in this case is that of exclusive possession. Every case of this type will always be fact specific. General points to come out of this particular case were noted to be that the occupiers were offered a choice of rooms before they moved in. The occupiers had keys to their own room but not to those of others, so individual occupiers had to give permission to anybody coming into their room. The question of exclusive possession also depends on the level of access and control that's retained by the landlord. Now, the points raised here were that the use restrictions determined how the occupier should use the rooms, which is a common feature of a tenancy, a lease, are not incompatible with exclusive possession, even if, as in this case, they were onerous restrictions. The court accepted that express reservations are usually seen in tenancies and the need for them arising from the existence of exclusive possession, but it didn't accept that the absence of express reservations meant the agreement had to be a licence. The court followed Street and Mountford. It's a landlord exercising limited rights of entry for the purpose of inspecting and repairing the premises was also not incompatible with the existence of exclusive possession. Inspections took place about every month, constituted a visual inspection of a room carried out from a doorway, and again not incompatible with exclusive possession, and therefore the court concluded that an AST had in fact been created. Now, by way of comment, from a recovery perspective, guardian schemes are a novel solution to the problem that many practitioners face with empty commercial properties. Whilst only a first instance decision, the case certainly reminds those working with properties and property owners that whilst they are a good idea, we do need to be really mindful of the basis on which those rooms or those premises are in fact given to occupiers. And that isn't to say that these schemes can't work. In fact, they can, and I think they're quite an innovative way of using a commercial property. Each case, as I mentioned before, will always turn on its own facts, and the law relating to licenses and leases hasn't been changed by the case, but it does give us some food for thought as to how an agreement might work. Now, when we're looking at guardianship schemes, there are other considerations to have over and above lease and licenses. For example, are you going to be breaching any other lease or indeed the mortgage that's in place? I guess typically if you're going to be in there dealing with it as a receiver or administrator, you're going to be referring to your powers in any event. But you do have to be mindful of other legislative breaches such as fire safety requirements, planning controls, any legislative implied terms which will be deemed to be included into a guardian arrangement by statute. So, for example, restrictions on eviction, considerations as to whether an arrangement means the property falls within a category of being an HMO, housing multiple occupation. So attached to those, there are licensing and planning regulations on as well. So lots to think about if it comes to a guardianship arrangement. Really interesting. Obviously, if you've got any arrangements you're concerned about, or if you're thinking of putting something similar into place, then do give us a shout and we can help you out on that. So let's move on to our next case. Recovering bona vacantia property. Now, it's a question which it's often divided many advisors on how you deal with property that has been dissolved, and further where that dissolved company's property has been disclaimed by the Crown after the company's been dissolved. I'm really pleased that this exact point has been covered in this case, because it's one that's caused many discussions both internally and externally over the years. It's really interesting that although the case was reported last year, I've not found a huge amount of commentary on it, and surprisingly for a change, it's one that provides receivers in particular with some really helpful points. You will be aware, this is fairly standard, that when a company is struck off the register of companies and dissolved, any property that it still owns beneficially immediately before it's dissolved then passes to the Crown. That's known as bona vacantia, which literally means ownerless goods. It's subject to restoration of the company, and if a dissolved company is restored to the register and the Crown hasn't transferred or disclaimed the company's property, then that property is deemed never to have left the company and is therefore vested in the restored company. That basically just uses the general effect of a company's restoration, that the company is deemed to have continued in existence as if it had never been dissolved. That's all those points are all pursuant to the Companies Act 2006, and has been prior to that, as I'm sure you'll know. The Crown's got various options how it treats bona vacantia property that it receives depending on what the property is. So, for example, leasehold, freehold, if it has liabilities or not. And it goes to different departments depending on what it is. If you want more information on those departments, then just drop me an email and I can talk you through those. The case that we're going to look at is called Re 5-Star Properties. It's a 2015 case, and it considered the position whereby the Crown had disclaimed a title whilst the company had been dissolved, which is something that's fairly common. I've dealt with a couple this year already. And before the case was heard, there were two conflicting authorities. The first one, Allied Dunbar Assurances plc versus Fowey, which is a 1994 case, that held that if a Crown disclaimed a lease, that disclaimer extinguished the leasehold interest, but importantly, the leasehold interest would be revived if the dissolved company is then restored to the register. Now, the second case was ELB Securities versus Love, and that was a 2015 case, and it was a Scottish case that held that a Crown disclaimer of a leasehold interest ended the dissolved tenant company's rights in the lease, and therefore the court could not find that the leasehold interest was revested in the tenant company when it was restored. The court here considered that the general effect of a company's restoration was subject to the specific statutory effect of the Crown disclaimer. Now, it's worth noting here, obviously, it's a Scottish law, it's not binding on us, but is obviously has influence. Interestingly, it was a case that was heard only a week or so before Re 5 Star, which we're going to discuss now. And we do just question, or we should question, whether the court actually knew about this second case. But certainly at the time that the Re 5 Star case was heard, the second conflicting case was in effect. So the facts. It's really good that it's deals specifically where a receiver was appointed, because that's quite rare these days. A property development company had fixed charge receivers appointed over freehold property it had charged to its lender. Receivers discovered that funds due to be paid to the company were still sat with the company's agent, and the lender therefore appointed administrators over the company to investigate the situation. Administrators did their job. They didn't sell the property itself that the receivers were appointed over, but instead moved the company straight to dissolution on the grounds that there was no property that would permit a distribution to creditors. I have assumed here that the property in question over which the receivers were appointed, in fact, had no equity. Following the company's dissolution, the tenant of the property served a statutory request for a new lease on the Crown, of the freehold property that is, that had gone at bone of vacantia. The Crown disclaimed the property as a result of that request. Despite the disclaimer, the registered freehold wasn't closed at the land registry, but a note was made on the proprietary register that the freehold interest had terminated. The lender subsequently applied for the company to be restored to the register and put it into liquidation, and also applied for the property to be deemed vested in the company, despite the disclaimer. Now, the court made the order restoring the company and put it into liquidation, but questioned whether it could revest the property in the company or not. Thankfully, it was held that it could retrospectively recreate and revest the freehold title in the company as if it had never been disclaimed. It considered there was no reason for the freehold and leasehold property to be dealt with differently, and basically followed Allied Dunbar case's authority that the leasehold title that had been disclaimed was revived when the tenant was restored to the register. Unusually, the court here took a really practical step and commented it didn't want freehold and leasehold titles being treated differently, and also it made the point that in practice the principal party that would suffer by any post-disclaimer revival would actually be the Crown itself, and that it didn't really need protecting against that sort of uncertainty. It had the option of disposing of the title rather than just disclaiming it. It also made a very practical point, actually, that the Treasury solicitor at the time that an application to restore a company is made has the ability to object to such restoration of the title and the company, and at no point did the Treasury solicitor do that. Interestingly, the court wondered why the application had been given in the first place, because it suggested there were other alternatives that could have been made. So, for example, it commented that the administrators didn't need to have moved the company to dissolution. The receivers could have continued in office and disposed of the property with the company still in liquidation, which is commonplace. I mean, we often deal with disposal of properties while a company is in liquidation. It just means that there's no agency relationship between a receiver or the company. And it also highlighted that because the lender's security interest wasn't terminated by the disclaimer from the Crown, the lender had the power to sell the property and vest the freehold title in the purchaser. and that follows a 1995 case, Similar Properties versus Gesso Properties, which is a BVI company. It actually also mentions here that if the court's assistance was needed to confirm the vesting of a title in a purchaser, then you can apply for that under a different order, which is something I've never done, but actually I'd be quite keen to do. That's under one of the sections in the new Companies Act 2000, I say new, 11 years old Companies Act 2006, and also under the LPA. Now the issues raised by this case, they're fundamental, particularly to us working in real estate recoveries. They go to the very existence of legal interests in property. What the decision does do is it agrees and reinforces the point that a Crown disclaimer is not a disposition, which is now somewhat a contentious point when you combine that with the disclaimed property that can revert to the restored company. And the reason I say that is because the Companies Act contains a protection for purchasers when buying bona vacantia property. Now, accordingly, for now, I think us as lawyers should be thinking about reports on title that we do to address the risks of a company restoration where the property has previously been subject to a Crown disclaimer, because obviously this case could cause issues there. Most commentators have cited that the court was helpful in highlighting alternative options for mortgagees that want to sell charged property that has been disclaimed. One thing it didn't mention, which I think it could have done, which would have been helpful, was how it would have differed, if at all, if no disclaimer had actually taken place. There is a school of thought which proposes that once the company is dissolved, the legal charge of the contract ceases to have effect because one of the parties no longer exists, and further that when a company is dissolved, all the property obviously goes to the Crown. Now, I've always thought this wrong. I've always been of the opinion that restoration of the company is not required prior to appointing receivers to dispose of a property, and that's for the point that was made in this case, that the power of a mortgagee to sell a property doesn't disappear just because a company has been dissolved. And the rationale behind that is that Section 4 of the Power of Attorney Act 1971 provides that if a power of attorney is granted by security and the donor's interest or obligation remains undischarged, which obviously it will do if a lender is seeking to recover a real estate asset, then that power isn't revoked by the dissolution. So I've always been of the view that you don't need to restore the company, but I've worked on numbers of cases where we've done that, and I've never had any issues. The Treasury solicitor's been involved in disposing of those assets, and it's always granted authority for the property to be sold as long as we've demonstrated that market value has been obtained for the property. This case has started me thinking about that, though, because I think it's interesting that the court didn't consider that as an alternative option. If we assume there's no difference between the Crown disclaiming the property or not, then I just wonder why it didn't go so far as to saying that the company didn't need to be restored. So I think my view on balance at the moment is that it probably is a safer option to suggest that lenders either just use their power of sale to sell the property rather than appointing receivers first. So if they do want receivers appointed, which there are obvious reasons why you might, which I shan't go into here, but the company should be restored. Interesting one, and one for more thought, I think. But all being well, the case may well be appealed, and the point may be covered at a later date, or at least commented on further. If anybody has any views on that, I'd be interested to hear what you think. Restoring the company isn't a big deal. It isn't a costly nor timely process particularly, but it is just one extra step that I've always felt unnecessary. Right, let's move on. This is the third and final case I'm going to discuss. The title itself is long. Whether a seller's equitable interest arising from an unconscionable bargain could be an overriding interest, and whether it was overreached. It's a mouthful. The case is quite technical. I did consider doing this one first, but I decided I didn't want to lose anybody's interest in doing it. It is a really interesting case. It is a good one to have, particularly in this market as things stand at the moment. There's still lots of things that have happened in the past which are rearing their heads in terms of falsities. It does require a little extra concentration on, certainly on my part, so I'm sure hopefully other people's do. So get yourself an extra bit of sugar or caffeine now and take a deep breath, and we will have a go. Because the areas covered in this case are themselves quite technical, in the interest of all of our sanity, I'm going to talk through the facts of the case first and discuss the points as we go along. So, Mortgage Express versus Lambert is the case. It was 2016, it's only just recently been reported. Again, a really good one because it involves receivership specifically, which is really good. Miss Lambert, refer to her as Lambert, owned a leasehold flat. She mortgaged to another lender. She ran into financial difficulties and the lender was seeking a possession order. Lambert's debt was $24,500. The property was worth $120,000. She didn't want to lose her flat though, and Ms. Lambert made contact with a Mr. Sinclair and Mr. Clement. They advised her that the flat was in fact worth just $30,000, but Lambert was keen to sell her property for that sum to get her debt repaid, and they also, Sinclair and Clement, were going to allow Lambert to remain living at the property indefinitely, rent-free for the first 12 months and £250 per calendar month thereafter, which was significantly below the market rent for that flat. When completing the sale, Lambert completed an overriding interests questionnaire without disclosing any of her occupational rights. Lambert's solicitors did query the level of the sale, and Lambert confirmed she wasn't being coerced into selling at the low price. On completion, Lambert gave full title guarantee of the property. She gave vacant possession on completion with a special condition, providing that any occupiers who signed the contract gave their consent to the sale and agreed that vacant possession would be given on the completion date, free from any estate rights or interest they had in the property, if any. We can all see this is going to go a little pear-shaped. Shortly after the sale was purchased, Sinclair and Clement mortgaged the flat with Mortgage Express for £102 and paid off a bridging loan they had taken to complete the purchase from Lambert. All the necessary registrations at the land registry were completed in a timely fashion. A couple of years later, Mortgage Express consented to the leasehold title of the flat being transferred to Sinclair's sole name. And in time he failed to maintain the mortgage repayments with Mortgage Express, and they appointed receivers over the property to recover the debt that Sinclair owed them. Lambert, as tenant of the property, fell into arrears with her rent to the receivers, and so the receivers began possession proceedings against her. Hopefully everyone's still with me. In the possession proceedings, which is what we're going to be looking at, Lambert brought a counterclaim claiming the sale transaction between her and Sinclair and Clement should be set aside on various grounds, and in the alternative, Lambert claimed an entitlement to a lease of the flat for a term of years to be assessed at the monthly rent of $250. Initially, at first instance, the county court held that, first of all, Lambert's claim to set aside the transaction on the basis of undue influence and misrepresentation failed. It should have been set aside on the basis it was an unconscionable bargain. And secondly, there had been a written tenancy agreement which would have been lost. It had been for an unspecified term at a rent of $250 and was converted to a 90-year lease by virtue of the LPA, 1925. Well, it did say, though, that Lambert was entitled to have the sale of the property to Sinclair and Clement set aside, but that entitlement was not binding on Mortgage Express. Accordingly, Lambert's counterclaim was dismissed and a possession order in favour of Mortgage Express was made, and Lambert appealed. So, what were the points raised? Now you know the basic, although voluminous facts. So the legal issues which the court had to consider on appeal were the legal character of a right to set aside a transaction as an unconscionable bargain. Now, the right to set aside a transaction on the grounds of misrep or undue influence has been classified as an equity or a mere equity. That's following two older cases, Bristol and West Building Society versus Mossview 98 and a Bainbridge versus Brown back in 1881. Now, the Court of Appeal here held there was no reason why a right to set aside an unconscionable bargain was in any way different. Lambert had a right to set aside the bargain that she made with Sinclair and Clement. The contract contained an unconscionable bargain, and therefore Lambert's equitable right arose when contracts were exchanged and not when they were completed. The second point that they looked at was how an unconscionable bargain fit in with the land registration system. So first of all, the court looked at whether the right to set aside an unconscionable bargain was capable of binding successors in title. Basically, Section 116 of the Land Registration Act 2002 provides that whilst not necessarily binding, an equity such as the right to set aside an unconscionable bargain is an interest capable of binding successors in title. So that was quite a straightforward one to tick, if you like. Next, the court considered whether the right to set aside an unconscionable bargain was capable of being an overriding interest. So a little bit techie here, but Section 3 of the Land Registration Act only serves to ensure existing rights are preserved. There is obviously the general rule that an interest belonging to a person in actual occupation overrides, subject to exceptions, but none of those exceptions apply. So Lambert's occupation could be an overriding interest and was proprietary in nature. Finally, it was necessary to determine whether the right to set aside an unconscionable bargain was capable of being overreached. Now, Sinclair and Clement were entitled to charge the property as owners, and they were free from any limitation affecting the validity of the sale to them, but neither could Mortgage Express's interest be challenged on that basis either, as the requirements for overreaching were met. If Lambert did have an interest that was potentially overriding, then it was overreached by the grant of the mortgage to Mortgage Express. The other point raised in the case was whether Lambert was precluded from asserting her claim against Mortgage Express. Now, although this point was unnecessary in light of the conclusion that an overriding interest was overreached anyway, the court helpfully, I think, commented that Lambert didn't disclose her right as an occupier to Mortgage Express at the time it took its mortgage, and therefore she couldn't seek to rely on that now. They also helpfully commented that it was irrelevant that Mortgage Express may have had notice of her rights because it had been made aware of the sale to Sinclair and Clement being at an undervalue. Now, it is an interesting one. The relationship between overriding interests and overreaching, of those interests being overreached, or overreaching, apologies, can give rise to tensions, and determining priorities between those competing claims can be difficult. I think the decision here confirms that an equity in the form of an unconscionable bargain can, in principle, give rise to an overriding interest, but that overriding interest is one that was capable of being overreached. Lenders were pleased by the confirmation, I think, and that a failure to disclose an interest doesn't preclude later attempts in asserting such interest against that lender. I think it's a great case. I think it's really helpful. I think it's one that will be referred to quite significantly going forward, both in practice and I think likely in the courts as well. So I think there's just a comment to have about forthcoming policy changes. These are set to take place this year, assuming obviously the result of the general election doesn't change anything, which I think in reality it won't, given what they are all about. First one, second charge regimes. Changes to the Financial Services and Markets Act in 2000 meant that second charge mortgages now have been brought into the FCA's mortgage regime. They've applied most elements of its existing mortgage regime to second charge mortgages on the basis that they pose very similar risks to consumers as first charge mortgages. Very briefly, the FCA's rules and guidance for second charge mortgages relate to matters such as disclosure, advising and selling standards, responsible lending, contract variations, fees, payment shortfalls and repossessions, general conduct of business standards, and and it also looks at second charges in niche markets. I think it may make second-tier lenders become a little more conservative in their lending approach, which might in time give them less requirements for recovery. That said, it may be that it was more typical for current first-tier lenders to move into that second charge territory, as it's now regulated in the same way. And I think in order to ensure they get their money, obviously they'll rank second now. They may choose to enforce earlier. So swings and roundabouts on the impact on that, I think. Underwriting standards for buy-to-let mortgages. The PRA issued a final version of a supervisory statement called Underwriting Standards for Buy-to-Let Mortgages. The document outlines the minimum expectations that firms should meet in underwriting buy-to-let mortgages, and they include things like affordability assessments, including tax liabilities, verified personal incomes, possible interest rate increases. They'll look at lending to portfolio landlords, which is defined as being 4 or more buy-to-let properties. And they'll look at using specialist underwriting process for those. The PRA also clarified that the provision in the capital requirements regulation, which reduces the capital requirements on loans to small and medium-sized enterprises by about a quarter, shouldn't be applied where the purpose of borrowing is to support buy-to-let businesses. I think the rationale behind the document was to bring all lenders up to current market standards, in essence, guard against the slipping of underwriting standards. I think the likely impact of this document will be very similar to that of the second charge regime. I think the idea is that it tries to curb cowboy lending, which could mean less aggressive lending, less aggressive recovery maybe from those sort of bridging lenders or shorter term lenders. But again, interesting to see what impact that may or may not have. Just before I finish, it's not policy change as such, but it is a change, a nugget of information for your information. While I was on maternity leave, I noticed this. A case last summer confirmed that receiver appointments of receivers constitute a change of control for corporation tax group relief purposes. It's a question that's arisen quite a few times on the larger transactions I've dealt with, but it's good that a case has now finally brought that to the fore and that confirmed that the appointment has the effect of degrouping a company, which is quite interesting, I think. So I hope you found some, if not all, of the webinar useful and interesting. Obviously, if there's anything you want to discuss, then please do let me know. Or if you've got any questions, then drop me an email. If anybody has any tips for me doing future webinars, please do let me know that as well. And I guess enjoy the rest of your National Love a Tree Day. As I said at the start, if you did spot the tree, let me know. It'd be good to see as many of you, and be good to catch up and have a coffee. Have a good day, and I will, all being well, do another webinar at some point in the future. Okay, thanks. Bye-bye.